Happy Tuesday. It's time for Coffee and Cursey Words. I missed all of you on Friday. Replay crew, we love you. The topics today will be timestamped down below. We have a lot of Britney stuff to cover. We have some Girardi updates, some very interesting updates. We have Erika fighting all of the lawyers on social media. I have thoughts that I will cover, but we're going to get into the new motions in the Britney Spears case first. After, of course, we say hello to everybody, and it's alive. And then we've got a few housekeeping measures we'll get into because I had family in town last week. We're going out of town the next week, so I will be missing 2 Friday Night Lives and 1 Coffee and Cursey Words. And then I will be back on August 10th for Coffee and Cursey Words, but I will still be around the socials. If you have not done it yet, go follow me on the socials. I am on Twitter for those of you that hate everything Zuckerberg touches, and I am on Instagram and Facebook for those of you that just don't care because it's social media. So at the Emily D. Baker on any social media platform. If anything pops off, I will be doing, not a Facebook Live, either an Instagram Live. I will try to do YouTube Shorts and Reels to kind of keep you up to date with stuff that happens because I don't expect any of these cases to slow down, but go ahead and let me know where you're coming in from, and go ahead and follow across the socials because that is the way to keep up with me over the next, week and a half. And it's time. I've got all of my Control F Yourself merch today. It's kind of this was my vibe this morning. Like, this is how I feel about Britney's dad. Like, I try to stay neutral on things. There's no neutral for me with Britney's dad. And if you haven't been to the Law Nerd shop, Control F Yourself is quite popular. And my oldest is like, doesn't that mean like go find yourself? I'm like, yeah, it's kind of like either go F yourself, go find yourself, go figure yourself out. Like, ooh, you're so mad. Like, go get that sorted, which came from a live stream where my computer was telling me to go F myself. So let's just get into it. I need to roll the intro and do the things that we do. Cheers. I can't believe it's Tuesday. I missed you guys. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey Words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see all of you coming in. We have so much to talk about today. I'm going to say a real quick hello. We've got lots of you from the UK. I saw you coming in from Benghazi and from Australia and from Ireland, from all over. So thank you for coming in. What else? There's a lot going on in the Olympics. Have you guys been watching the Olympics? I've been watching the Olympics some, not as much as past years, because the coverage is kind of like duplicated. Like, you can watch it live in the morning because of the time gap between here and Japan, but also then they recap it at night. I saw the stuff going on with US women's gymnastics. I don't know everything that's going on. I know that Simone Biles withdrew from competition. Look, man, she's the GOAT. I feel for her. If she's like, I just can't do this, I'm like, yes, girl, set those boundaries. Be like, I just can't do this. And if I keep trying to push it, I'm going to hurt myself. Good. Healthy boundaries. Good for you. It's hard to do. I can't imagine. But then again, I was an athlete that would never admit that I was hurt until I absolutely destroyed myself. So, perspective matters. I am working on the brighter lips. So today, because I know you will ask, we've reached this stage of life. We've reached this stage. We've reached like, oh, what is it? I think it is Wild Berry Tart. It is a Supreme Lip Cream from Gerard Cosmetics. You know how I feel. I love. It's nice and soft. It's more of a cream than a gloss color. I like it. So let's just get in. Do you guys want to hear Girardi updates first or Britney updates first? I think I can guess. I'm not even going to put on a poll. 1 for Britney, 2 for Erika. Let me know. Erika is going to be the shorter one. Britney's going to be the longer one. But what are you guys here to hear about? You let me know what you're here to hear about, and we will get to it because that's what we're here to do. We're going to let you guys pick what you want to hear. You guys are here from everywhere. Tuesdays work so well for all of the international crew. So it's always good to see you. Anaheim, California. I'm going to be seeing y'all soon. That's going to happen while we're traveling. That is going to happen for sure. All right, let's see what you guys are saying. Britney. It's Britney, bitch. Y'all are like Britney. A few of you said Girardi. Britney. James says, feels like Rosengart has backed Jamie into a corner with this petition. How do you think Jamie's attorney will respond? This is going to be my facetious answer, and then I'll get to my serious answer after we go through the petition. My facetious, why is that hard? My facetious answer is, he's just so hurt. Britney's daddy loves her, and he wants an opportunity to defend against hurtful allegations. He loves and misses his daughter. Actually, that might actually be how she responds. That might actually be what happens. All right, we need to get all the way into this Britney document because there are 2 of them and there are transcripts attached, which does bump the length. But the court hearing that was not made available to the public, after the LA Superior Court ended the remote audio attendance program because the Britney case leaked everywhere, that transcript's attached, and I find that very, very helpful. So I am going to catch this super chat, and then I will swing back and get super chats as we switch topics. Oh my God, first live. Hi from Sweden. Love your videos. Thank you. I find them so informative. Thank you. Looking forward to seeing your vid on Blizzard Activision. Thank you so much, Kennedy. I think that's how I pronounce that. Hopefully I am right. I've gotten hit up on social a lot about this, and I realize I've been answering under each person's post and not just posting. I am covering that in tomorrow's episode of the Emily Show. It is very triggering. The stuff going on with Blizzard Activision is very sad for women that work in male-dominated fields. I'm sure it's not a surprise. There are some very detailed allegations in there. That is a separate episode, so people can, that is not an episode that can be mixed in with like the other pop culture stuff. It is very heavy. It is very deep, and it is the employment law stuff on there is very sad. And I had feelings, so I ranted about it. I was angry. I gave everyone a warning. So, hello, blue-eyed country gal. I am always here for the sultry sounds of my voice. Watch as my career extends. I want to read audiobooks. I've talked about this. The audiobooks, I have goals. All right, let's get into the Britney stuff first, and then we will do a Girardi wrap up before we get to Q&A. I'm sure all of you will have tons of Q&A. Hello from Ocean City, New Jersey, Dr. Sarah, one of my favorite places to visit, both in the winter and in the summer. Some not in August though, not this time of year. All right, Britney Spears first. As you guys know, in the Britney Spears conservatorship case, Britney has had enough. Britney has put her fucking foot down. She is just like, I am done with all of it. Her attorney of 13 years, Sam Ingham, resigned after her June 23rd statement to the court. It was not a statement. It was a calling out. It was I've had enough, and this is fucking bullshit. After her statement to the court, he resigned. Her new attorney, Rosengart, has filed his first motion in court on her behalf. There were other hearings that happened in court yesterday just to bump the date of this petition, so nothing big there. It just moved up the date. So you're going to see a December date on these petitions. They have actually been moved to September, not December. So we will see these being heard at the end. That gives Britney's dad time to respond, which is appropriate. Or to resign. Every time Sam Rosengart has appeared in court, it seems that he has called on James Spears, Dad Spears, to resign, saying the conservatorship is supposed to be in what's Britney's best interest. You are not that. We're calling on you to resign. If you're not going to resign, we're going to petition to remove you. And that's where we're at today. These were filed on July 26th, which was yesterday. So let's get into these documents now that we've done a quick road so far. I need to, Emily, share your screen before you go live, girl. Before, look, we're professionals here. Professionals, people. All right. This is a 20-page petition. You'll see a lot of these. These are the checkbox petitions, the court, documents that go through all of it. We're just going to go through what this petition says. This is not the juicy one. We'll get into the juicy one in a minute. This is the conservatorship of Britney for a successor conservator of the estate. The successor conservator bond be fixed at $47 million to be furnished by an authorized surety company and otherwise provided by law. Look, conservators are professional fiduciaries. This could come back to bite James Spears in the ass, and maybe it will. Professional fiduciaries. They have obligations. They are bonded to make sure that they do not drain the estate or loot it of its assets or anything like that. Now, look, the potential successor of the conservatorship is listed here with their business phone number. Don't call them. Just don't do that. These are public records. This is a business phone number. It's not like you can't find this person, but I just want to make that caveat because court documents. So Jason Rubin is a CPA, CFF, ABV, ABCD, EFG, XYZ. All of the things. They are a certified CPA. They have experience in large estates and are a professional fiduciary. And we will get into that in a minute. So we'll get into that relationship. So they're fixing the bond at $47 million, which is a lot of a bond. Think of like a construction bond. The bond can get put up if you fuck things up. James Spears also has a bond. I don't remember the amount off the top of my head. So they're asking for orders authorizing an independent exerciser of powers under the probate code as a successor. Let's get to the other checkboxes. Other orders to be granted, attachment 1. These are the other powers that have been granted to the other conservator of the estate, James Spears. So I expect that those will be the same. Those also came up when we were looking at Bessemer. So we'll see if they're exactly the same. We'll read them in just a minute. The petitioner is the proposed conservatee. We know that. And they say proposed because she is the conservatee, but it's proposed to be the conservatee under this new conservator. Proposed successor conservator is a nominee, a professional fiduciary as deemed by the Business and Professions Code. His or her statement confirming licensure is attached. So we'll see that. By a nominee, they mean this is Britney and her team nominating this person as the fiduciary. This person also has skills in forensic accounting, as we'll get into. This is something I've said from the beginning is needed and is a good thing. You need someone who can do forensic accounting to look into everything that's come before. And this is someone chosen by Rosengart, not somebody chosen by Sam Ingham or by Dad Spears. So in Rosengart's work, he probably has people that he's worked with and somebody that's willing to take on a large estate like this. And we will see. So let's keep getting into the rest of this document. So far as known to petitioner, a conservatorship or equivalent proceeding concerning the probate conservatee has not been filed in another jurisdiction, meaning this is the only place where this is governed, is not a patient in an inpatient hospital, is not entitled to receive benefits from Veterans Affairs. These are all of the necessary checkboxes to go through. Vacancy in office of conservator, a petition for appointment of a limited conservator after death of a predecessor in a petition for an initial appointment of the estate specified. The petition is being filed concurrently. So this is saying that this is a vacancy because they're not asking for a co-conservator. They are asking to have Dad Spears removed. So this is not after death. This is as specified below, which is the petition to remove James Spears. Proposed conservatee voluntarily requests the appointment of the successor conservator. Again, this is a request. I know there will be questions when we get to Q&A about why aren't they just terminating the whole thing. I have thoughts. We'll get to that as we get to the end and get to questions. Proposed conservatee will attend the hearing and is the petitioner has nominated the successor. So there will be a hearing. Britney will be at the hearing. She wants to be heard about bringing someone else in on the money, which is good. These are the people that are being notified of all of this. The address that says on file with court is to protect the addresses. The other addresses are law firms. So you've got, Brian Spears, Jamie Spears, Lynne Spears, the kids, K-Fed, and Dad Spears. So this is all of the people who are getting notice of this. This is the signatures. This is Britney's signature. Attachment 1D, additional powers. These are less additional powers. There's the rest of the other orders. Okay. Independent powers, the power to operate for a period longer than 45 days at the risk of the estate, a business or enterprise constituting an asset of the estate. So that is the hybrid business model. Now, this does not mean performances. This can mean things like perfumes, licensing deals, all the things that are the business, allowing those things to continue to operate and run, because that is something that is unique within a probate estate. The power to pay, collect, compromise, and otherwise adjust claims, debts, or demands upon the conservatorship as described in the codes. That's the probate code. So paying the bills, negotiating for better deals with professionals, things like that. Other orders, the power to obtain all documents and records relating to the conservatee and her assets. Yes, whether held in her name or the name of another, all contracts, information relating to credit cards, bank statement, estate planning documents, receivables, and all powers of attorney. Give us everything. We're starting at the beginning and we're reviewing it. The power to take all actions necessary to secure their assets, the power to revoke all powers of attorney. These are from the previous ones as well. The power to commence and maintain litigation, the power to perform any and all acts that conservatee can perform, and then going through the, taxes and checks and stuff like that. These are all the previous additional orders, so they're not seeking to change those. Prosecute civil harassment, authorize and pursue professional opportunities, meaning to sign contracts for professional opportunities like TV and other, if they are approved by conservator of the person and medical team. We talked about this a while back, that for years this order stood, and the person, James Spears, Dad Spears, was getting a percentage of all of her performing and whatever, 1.5%. He was also the one deciding the contracts and approving them, because it had to go through the conservator of the person in the medical team. Well, he was in charge of that, and he was in charge of the money. So he could just be like, oh yeah, we're good. We're good. We've chatted. We've chatted about what's best among ourselves. That's not going to happen here now that there are independent and professional fiduciaries, hopefully on both sides, when Dad Spears is removed. The power to select and invest, the power to employ attorneys and accountants. Right. They can do that under the additional powers. Whether this conservator of the estate will need to is different, but that's part of where Dad Spears has the authority to hire attorneys. There are other authorities he's granted to hire attorneys, but this is part of it. The power to contract for the conservatorship, the power to assert the rights in any trust established for her benefit, including revocable inter vivos trusts established by the conservator, a settlor, or trustee. So that's dealing with her estate and moving things in her estate. This is the petitioner's nomination. This is a very, basic removal and nomination. Here, concurrently with however, it is written different than the nomination for Bessemer. The nomination for Bessemer said we nominate Bessemer as co-conservator. Here, concurrently with this petition to remove petitioner Britney Jean Spears as conservator of the estate, is filing a petition to appoint Jason Rubin as the successor conservator of the estate, and Ms. Spears hereby nominates Jason Rubin to fill that post. Pursuant to Probate Code Section 1810, Spears respectfully submits that this court should appoint her nominee in that it is in an objectively intelligent preference to nominate a highly qualified professional fiduciary in this circumstance. The shade. Ms. Spears submits to this court should appoint her nominee, saying that her nominee is an objectively intelligent. It is her objectively intelligent preference to nominate a highly qualified professional fiduciary, vis-a-vis her father, potentially not highly qualified nor a professional fiduciary. Moreover, Spears respectfully submits that given this court's recognition at the July 14th, 2020 hearing that Ms. Spears has sufficient capacity to choose her own legal counsel, she likewise has sufficient capacity to make this nomination. Hey, Your Honor, remember when you said this month that Britney can choose her team? There's nothing you can do to back out of that. Like, the shit is out of the horse. We've tipped the boulder over the precipice. It is rolling downhill. It will flatten Dad Spears. You can't undo it. If she has competency to hire counsel, then she has competency to hire her own professional fiduciary. What would you like to say about that? Like, what is the argument? It leaves no room for the court to argue with that. This nomination is made without prejudice and without waiving Mrs. Spears' rights. This is her signature on this one, which looks to me different than her signature on this one, but okay. I just have to note what I see. It doesn't mean it's different. I don't know what number that is. When would this have been signed? I don't know. Today's the 27th, maybe the 24th? I don't know. I don't know when this would have been signed. It's interesting to me. All right. Attachment 3E15. Petitioner's new counsel of record does not yet have the client files from prior counsel. Really? Rosengart doesn't have the case files from Ingham yet? Ingham knew this was coming, and Ingham made his own petition to resign. Don't you get that shit together before you resign? Like, put the files together before you resign. Maybe. I know transferring case files can need write-ups and stuff, but you could at least get started. I digress. Petitioner's new counsel of record does not yet have the client files from prior counsel. However, on information and belief, based on the August 13th, 2020 petition of appointment for Bessemer Trust Company of California. Yeah, they asked for that to happen in August. The court finally granted it, and then he never filed the petition until June. Really? I mean, when you make the appointment, you would just write up the mock order, the mock-up of the order. I digress. August 13th, 2020, petition for appointment of Bessemer Trust Company, conservator of the estate, which petition was executed and filed by petitioner's prior counsel. The following is a true and correct copy of what was attached as Schedules 13A and B to the redacted 12th account reporting of James Spears, conservator of the estate, petition for its settlement and approval thereof. Filed conditionally under seal August 6th. Note, these schedules as filed by James Spears contain a typographical error, which refers to the 10th account current. However, Mr. Spears alleges that they actually set forth the property on hand for December 13th, 2019 on the closing date of the 12th account, being the 12th accounting year. So they don't have everything, but we're going to get into the property on hand at the end of the 12th account. These are not the redacted portions of the 12th account. So we're getting into money stuff. Of course, the account numbers are redacted out as they should be. Property on hand at the end of the account period. This is the end of the 12th year of the conservatorship. Cash assets. These are bank accounts and, annuities. $466,000 in liquid assets, essentially, from different checking accounts. Merrill Lynch investment accounts. 5 investment accounts at over $2 million. Morgan Stanley investment accounts at over $2.7 million. Other Merrill Lynch accounts, mutual funds, equity, fixed income accounts at $22.4 million. Other investment accounts at $14 million. And then investment bureau assets at $8 million, real property at $7.4 million, personal property at $1.5 million, personal property being cars, jewelry, things like that. Out of state property in Kentwood, Louisiana. That's probably her mom's home, I would imagine. So at the end of the day, they're looking at the total assets on hand at $57.3 million. Now, I realize to most of us that seems like a fuck ton of money. It seems like a lot of money. But she was making hundreds of millions of dollars on her tours. So though it seems like a lot of money has been spent in this. Here's the good cause statement. Petitioner is the conservatee and requests appointment of the successor. Good cause exists to appoint this nominated successor because a vacancy in this post requires filling. The vacancy that we're going to get into in a moment. Pursuant to Probate Code Section 1810, petitioner respectfully submits that the court should appoint her nominee and that it is an objectively intelligent preference to nominate a highly qualified professional fiduciary in this circumstance. Again, it makes sense to have someone who is a professional managing a almost $60 million estate, not, Dad Spears, not a CPA, not a professional fiduciary, and can just, go back to whatever it was that he did before this. This nomination is not made with prejudice. We covered that up above. This is the professional fiduciary attachment stating that they are a licensed professional fiduciary. And that is the end of that. Are you ready to get into the petition with the declarations? Are you ready? Are you ready? Are you ready for it? Yeah, I heard it in my head. Boom, boom, boom. Are you ready for it? Boom, boom, boom. I know. I'm writing down timestamps. Let's get into this motion, shall we? Shall we get into it? There's declarations. You know what declarations mean? Declarations mean people have sworn statements and they have a lot to say. The declarations from Britney's mom is the one I'm most interested to go over with y'all, though we're going over all of them. This is the verified petition for suspension. Why was that word hard? Suspension and removal of James P. Spears as conservator of the estate pursuant to Probate Code Section 2650, nomination of successor conservator of the estate, supporting declarations of Jodi Montgomery and Lynne Spears. I will note, this has been tried before, not in this way. They appointed, and if I remember correctly, I will go back and I did not go back and look at the documents because I didn't even think about it. But when Bessemer Trust was being brought on, they asked to remove James Spears. I think doing a motion with an opportunity to respond makes the most sense. At that time, the court denied the motion to remove James Spears, but denied it without prejudice and said the court would be open to hearing that motion again. I think bringing the motion, focusing on the best interest of Britney, and bringing these additional declarations makes a ton of sense and is a different approach than how we saw Sam Ingham approach the same thing earlier. Petition for suspension and removal of Dad Spears. Let's get it. Do we love this? I love this cup, by the way. I'm geeked about it. It's like purple and blue and fabulous. For more than 13 years, petitioner Britney Jean Spears has endured a conservatorship that, certainly as it concerns Dad Spears, has grown increasingly toxic and is simply no longer tenable. Do you think they picked the word toxic specifically because it's such a great song? Or do you think they just wanted to call Dad Spears toxic? Or do you think that it's just like, no, that's the best word to fit the scenario? I'd love to know your thoughts on that. Let me know. There might well come a time when the court will be called upon to consider whether the conservatorship should be terminated in its entirety. I don't like that it says there might. Lawyers pick words very specifically, particularly in writing, because when you say stuff just kind of sometimes happens when you're talking contemporaneously. But when you're writing, you're going back over it. This is not we are terminating this immediately. This is there might come a time when the court will be called to consider whether this should be terminated in its entirety and whether, in addition to stripping his daughter of her dignity, autonomy, and certain fundamental liberties, Mr. Spears is also guilty of misfeasance or malfeasance, warranting the imposition of surcharges, damages, and other legal action against him. Coming out of the gate very strong, saying that though we may ask to terminate this later, we may also need to look into what in the ever-loving fuck Dad Spears has been doing. There might be breach of his fiduciary responsibility as a professional conservator. not a professional, but as the conservator of not just the person, but of the estate. If there was overstepping of his role, I think it seems like that might be the case to all of us. We will see what happens, but the imposition of surcharges, clawing back money, damages for the harm that was done, and other legal action, which may also include criminal prosecution. Let's look at the footnote. Indeed, serious questions abound. No shit. Well stated. Yes, they do. Yes, they do. Serious questions abound concerning Mr. Spears' potential misconduct, including conflicts of interest, conservatorship abuse. There it is. And the evident dissipation of Miss Spears' fortune. Where the fuck is the money? Which Mr. Spears has effectively controlled since 2008 by himself. Him and Andrew Wallet had it before then. As Forbes reported, by 2008, Spears had released 5 hit records and embarked on 6 major tours. In the decade that followed, post-conservatorship, she delivered another 4 albums and 4 world tours, as well as a Las Vegas residency that ran from 2013 to 2017 and grossed $137 million, according to Caesars Entertainment. Where'd it go? Where'd it go? Oh, I don't know. Emily's speculation. To the attorneys that are charging $500,000 for media matters, maybe? To Dad Spears getting over $16,000 a month plus $2,000 for rent. Okay. Well stated. Coming out hot. We like it. That's not a sassy footnote. That's a fuck you footnote. Yeah, that's what that is. Nevertheless, although our investigation into these issues and others is active and ongoing, I would hasten to say it's just at the beginning. This petition does not ask the court to address such issues today. Your Honor, the shit's going to hit the fan, but first we need to get him out of the position where he's in charge of the monies. Instead, this petition asks the court to take the initial narrow step within its broad discretion of removing Spears as conservator on the grounds that do not even require Mr. Spears to be at or admit to fault. Just yeet him. Just yeet him. You don't have to even say he did anything wrong. Best interest of the conservator, yeet. You don't have to make any Your Honor, let me make this easy for you. All you have to do is yeet. That's it. No findings, no nothing. We'll get to that later. We'll come back to that. But now, just remove him. That's all. We've made it so simple for you, Your Honor. So simple. Specifically under Probate Code Section 2650, sub J, the court has broad, quote, discretion to remove a conservator where the court deems that removal is in the best interest of the conservatee. And that is the argument that they are making here. That's it. Is it in the best interest of Britney that he's gone? Well, we've heard her talk to court twice, and she sure the fuck thinks that it is. And the court has said that she will take into consideration what Britney has had to say. Britney has had to say multiple times she wants her father out. She said she wants her father locked up. She wants her father prosecuted, but she wants him out. She has made it clear that this is going to be, it will be very difficult for the court to try to justify not granting this motion. If the court's inclined to do so, I hope that that's not the case. This controlling provision stems from the bedrock principle, not always do we get to bedrock legal principles, but this is actually like foundational legal principles. The bedrock principles of conservatorship law, acting in the best interest of the conservatee, which has been Rosengart's rallying cry. He's like William Wallace screaming freedom. He's like, best interest of the conservatee. How the fuck have we gotten so far away from that very simple principle that should be governing this thing? Freedom! That is what he has been yelling in this. In every interview I've seen, in the statements in court, he keeps coming back to best interest of the conservatee. Although new legislation might, in fact, be warranted as a result of the Kafkaesque nightmare, I think this is an age definer, whether we get the Kafkaesque quote or not, but that's a conversation for another day. The Kafkaesque nightmare which Miss Spears has been faced, the legislative intent behind the probate code is clear: to protect the rights of persons who are placed under conservatorship. Oh, I didn't realize there was a second paragraph to this footnote. Hold on. Back to the footnote. I didn't realize it was I thought it was a second footnote. I kept waiting for it to come up and then it didn't. They say it is, quote, therefore not surprising that Forbes concluded that under the circumstances, Britney's net worth is, quote, shockingly low, and that although no one knows what she, quote, would have done had she been in control of her fate and fortune, it's not hard to imagine she would have done. It is hard to imagine how she would have done worse than her estranged dad. And this is a Forbes article link that I will put. Oh, look, hyperlink is so helpful. I'm just going to put it in the chat for y'all, so you can save it. I will also put it in I'll put it in the description of the video. Look at me being like an adult YouTuber and stuff. I'll put it in the description too, so you guys can watch it or read it. Okay, back to the protection of the rights of those under conservatorship. Like, that's the whole fucking point. Literally, the whole point is to protect people, not to raid them of their funds and dignity. Legal scholarship has also emphasized how this goal remains consistent throughout the code. And then they go on to quote the different writings that say that the bedrock principle is in fact the bedrock principle. Like, I'm not just saying words. This is what is believed and widely understood to be the actual purpose of the entire fucking thing. Protect the interests of the conservatee. Repeatedly, the need to consider and respect the conservatee's own wishes when determining actions in her best interest is apparent from the statutory directive provided to the court investigators to assess a conservatee's wishes and determine if the conservator is acting in the best interest of the conservatee in each periodic review under the probate code. They say that the Judicial Council's Handbook for Conservators also provides a clear mandate to respect the conservatee's wishes. Quote, the position of conservator is one of great trust and responsibility. The court and the conservatee are trusting you to follow the law and to act in the conservatee's best interest. You should make choices that align with the conservatee's capabilities and wishes, that support, encourage, and assist the conservatee, and that are in the conservatee's best interest. This is why Rosengart keeps calling on James to resign, because if Britney wants you out, the best interest of the conservatee is that James Spears resigns and not spends more of Britney's money on lawyers fighting what is in her best interest, because that's not in her best interest. This is starting to piss me off. It's not pissing me off. The situation pisses me off. And as I'm reading through this, the fact that Rosengart even had to file this is pissing me off, because it became clear in the last several hearings that what Britney wants more than anything is her father to be the fuck out of her money and to leave her alone. And resigning is what's in the conservative's best interest. It doesn't matter what he wants. His interests don't matter in this circumstance. Indeed, during the July 14th hearing, the court itself instructed that, quote, everybody should be working collaboratively to help Ms. Spears get to the point she's trying to get to, that she's articulated in the last couple of hearings. So it's not about anyone else. It's about her. Right. And that signaling from the court indicates to me that the court I don't see how the court can deny this motion. The court is in a position where Rosengart has given the court the law, the fundamental governing principles, and is going to come in with the things that James Spears has done that go against Britney's best interest, and said to the court, these are all the reasons you have to listen, to yourself. We'll get into that transcript in a little bit. It's attached. Against this backdrop and Spears's own courageous June 23rd and July 14th testimony, it cannot genuinely be disputed that whether one, selfless and exemplary, as Mr. Spears would presumably contend falsely, or 2, self-interest is or violative of Title 18, violative of Title 18. I hate that word because it looks like violative to me, but it's in violation of Title 18. It's just a hard one for me to pronounce. Dad Spears' service as conservator has become and now is extremely detrimental to the central issue, the well-being and best interest of Britney Spears, which this court quite correctly, Your Honor, we defer to you. Your Honor, this is well, there could be a few more commas that would aid in the reading out loud, but this is very well written. Here's why. It is laying out for the court all the things the court needs to say. Your Honor, here is the bedrock principles. Your Honor, here is what you have previously said. Your Honor, here is what you have recognized in the future or in the last court hearing. Here is what's in the best interest of Britney. Here are the stepping stones to get you from this petition to the ruling that we're asking you to get to. And it steps the court along each step of the way and makes it very easy for the court to highlight this and sit on the bench and go, I find that it is in the conservatee's best interest that James Spear be removed under this principle, this law, and this is why. This makes it very easy for the court to put together their ruling. And this was clearly written with that in mind. Make it easy for the judge. Also, flattery will get you everywhere. The well-being and best interest of Britney Spears, which this court quite correctly has recognized must be the controlling factor. Your Honor, as you previously said, so wise. Please do the thing we're asking you to do. And given the uncontroversial basis for this petition, any father who genuinely loves his daughter and has her best interests at heart should willingly step aside in favor of the highly respected professional fiduciary nominated here. The goal is to act in the best interest. If you wanted to act in the best interest, what you would do is resign. Now. That's what Rosengart is saying, and very pointedly and clearly. Let's talk about Jason Rubin real quick. Jason Rubin is a CPA, EFG, HIJK, and a California licensed professional fiduciary, well known to this court. Mr. Rubin, that's helpful too, to find someone that's practiced before the court. Your Honor, Jason. You've worked with him on other cases because if he's a professional fiduciary, he probably has other complex estates that he works on. So the court knows him as well as the attorney. Mr. Rubin has been practicing as a licensed professional fiduciary since 2001 and has been appointed by the LA County and other county superior courts as a special administrator, executor, trustee, and conservator of the estate and person. Rubin has significant experience managing trust estates and conservatorships, including complex portfolios for high net worth individuals, real estate, and closely held non-real estate companies and other financial assets valued in the hundreds of millions of dollars. Previously, Rubin was employed as a forensic accountant. We love that. What we need here is someone to dig through all these books with a forensic lean, with that in their brain as they're looking through things going, I have questions. This doesn't make sense. We love this. Previously, Rubin was employed as a forensic accountant and financial specialist for the law firms of Munger, Tolles, Olson, Howery, Simon, and other people, and was manager of the dispute analysis and investigation practice at PricewaterhouseCoopers, along with more than a decade of experience as a CPA with major accounting firms. And then that refers us back to the petition that we already covered because that one was shorter. That's why I went first. Regardless, freeing Spears from the control of a conservator whose presence is inimical. Look, this one's hard for me too. There's too many eyes. We're just going to go with it. To his daughter's well-being cannot wait, nor should it have to. In fact, if Mr. Spears were to oppose this outcome on the grounds previously suggested, his opposition would reveal his true priorities. How do Dad Spears' lawyers craft a response going forward when it's already been stated in the shots across the bow? If you oppose this, we see you. And we see exactly that you don't have Britney's best interest in mind. We've got you. Like, there's no way to argue around that. His opposition would reveal his true priorities and whether removal would be also appropriate under other grounds recognized by the probate code. That means we are now, if you want to oppose it and reveal your true priorities or motives, then perhaps there are other grounds under the probate code that we could bring up for findings of wrongdoing, etc. That is a warning that would come next. That's not a veiled warning. That is a warning. Danger, Will Robinson, danger. Dad Spears should be removed and replaced. Pursuant to the above, Britney alleges as follows. Background and parties. In 2008, Ms. Spears was placed into this conservatorship with her father, Dad Spears, taking control of her affairs. As the conservatee, Spears has standing to bring this petition to remove Dad Spears as conservator. Britney is 39 years old and resides at the address on record with the court. February 1st, 2008, Dad Spears was initially appointed as temporary conservator of the estate. On January 5th, Dad Spears obtained a court order removing the temporary label from his post. Dad Spears has profited handsomely off his daughter's conservatorship. By way of illustration only, since at least 2009, Dad Spears has been paying himself $16,000 per month from Miss Spears' estate, $2,000 more than he has allotted for Miss Spears. Mr. Spears also pays himself an additional $2,000 a month for office expenses, again from Miss Spears' estate. Remember when Dad Spears said that, as a professional fiduciary, Jodi Montgomery should handle her own costs? Why is he paying himself rent then? Also, that totals it to $4,000 a month more than Britney is allowed to spend on herself. According to his June 12th, 2021 declaration in support of his petition for compensation, Mr. Spears presently seeks compensation for working with his lawyers to address public media and social media attention, which includes reading major television and news articles, social media posts, global media inquiries, and documentary films while reading and watching. Mr. Spears also seeks compensation for continuing to do my best to keep current regarding the music, advertising, and entertainment business. You're not the business manager. You pay a business manager and yourself. So why are you paying yourself to act as a business manager? Because that's not what you are. Oof. Mr. Spears has also paid multiple teams of expensive attorneys to represent him and the conservatorship, including in actions routinely against Britney's express wishes, while until only very recently, Ms. Spears was assisted by a single court-appointed attorney. He had flying fleets of lawyers, and she had one person, Sam Ingham. Ooh, let's get it. Let's talk about litigation counsel. His litigation counsel, H&K. Look, I found the picture. I will post it on social media today. I found the picture that I was thinking of the Hell's Kitchen in Vegas that looks like the Holland and Knight logo on their letterhead. I'll post it on social because every time I see H&K together, it just looks like Hell's Kitchen to me. H&K alone seeks compensation from Britney of $1.3 million in attorney's fees from October 17th to June 30th. I've covered those in other documents. There's a whole Britney playlist on the channel if you want to see me go over that. This includes, the controversial $500,000 for media manners, which is more than any other category of expense, despite an alleged reduction of $100,000. So he's pointing out and reminding the court that they took off $100,000 from the media matters and that it would have been $641,000 in media matters. How is that in the best interest of the estate is what I've been asking since the beginning. In addition to that monthly compensation, Dad Spears has paid himself a share of the revenues generated by Spears' performances. He reportedly received 1.5% of gross revenues generated by Miss Spears' performances. We'll get to this footnote in a second. and merchandise sales associated with her highly successful multi-year Vegas residency. These gross revenues for box office alone were approximately $137 million plus merchandise sales. Mr. Spears' cut from the residency is estimated at least $2.1 million. He also received a $2.95 commission on Spears's gross revenues for her 2011 Femme Fatale tour, which yielded an approximate $500,000. Why? Because he would have approved, he was at that time covering the estate and he was signing the contracts as a person. There were no checks and balances here. He was negotiating the contracts, negotiating these in for himself, not checking it against his duties, it seems, from any of this, and then also approving it as the conservator of the person, going, oh yeah, you should pay yourself that. For what? Because there were also business managers. We saw all the money Lou Taylor was making and the percentage her company was making before they resigned in the pandemic. My opinion, because Britney wasn't touring, so it only made sense for them to resign, and because Ingham started objecting to how much Dad Spears was approving to pay them, finally. So what was he getting a percentage for? For what? For doing what? He wasn't her business manager. A business manager was already taking a cut of things. Let's look at these footnotes. Dad Spears' share of the gross revenue is less amortized of pre-production expenses and running show costs for sounds and lights. Okay. Britney Spears' Piece of Me Vegas residency tour final figures, 248 shows, 916,000 tickets sold, $137.7 million earned according to Billboard. And then there was another footnote down here that Britney Spears quietly pushed to end her conservatorship for a year. Oh, there's the New York Times article that we've talked about in the past. All right. Although it is common for managers, agents, and other industry professionals to receive a percentage of an artist's earnings, Mr. Spears is none of these. I should have just kept reading instead of ranting. When will I learn? Never. I will never learn. I will keep ranting and then read it and go, oh, we were on that's where I was going with that. Mr. Spears is none of those. He is a conservator, and as a conservator, his role is to be burdened by rather than benefit from the conservatorship. Well, at least somebody fucking said it. Dad Spears is not a professional business or financial manager. No shit. In fact, the Spears family struggled financially under his leadership and filed for bankruptcy in 1998. Whoop. There it is. Footnote 6 at id. Id to what, though? Oh, the New York Times article. Although at various times there have been co-conservators of the estate along with Mr. Spears, since the court July 14th, 2021 approval of the resignation of Bessemer Trust, Mr. Spears has been and currently is the sole conservator of the estate. Britney's doctors have previously opined that the relationship between her and her father has soured to the point that removal and replacement of Dad Spears is in the best interest of Britney Spears. As recently as during the July 14th, 2021 hearing, counsel to conservator of the person, Jodi Montgomery, stated unequivocally, this is Jodi Montgomery's lawyer, that it has been a, quote, strong recommendation by the medical team that Mr. Spears, her father, needs to be off of the conservatorship. And that is from the hearing transcript at page 47, which is attached. The relief requested by this petition is supported by other interested parties, including Jodi Montgomery, conservator of the person, Lynne Spears, petitioner's mother, all of whom agree that removal and replacement of Dad Spears is in the best interest of Britney Spears. Specifically interested party. These are the highlights. This is the highlight reel. This is the clips version in case we don't read the rest of it, which we're going to, but this is the clips version. Specifically interested party Jodi Montgomery has now declared under penalty of perjury that it is her strong opinion and recommendation that the persons serving as Miss Spears conservators not be family members. Instead, it is in Miss Spears's best interest that only qualified, neutral, professional, and corporate fiduciaries serve as her conservators. A corporate fiduciary is like Bessemer Trust. So where it's a larger company that's managing all the things. A professional fiduciary is like Jodi Montgomery, the individual, or the proposed individual here, Jason. I was going to say Rund because that's the, trustee for the Chapter 7 bankruptcy in the Erika Girardi case. And My brain is full of names, but the one that they are seeking to appoint in this one, his name will come back to me in a moment. Ms. Montgomery has also declared as follows, quote, I have had numerous ongoing conversations with the medical team, and we all agree that it would be in the best interest for Mrs. Spears' well-being and mental health that her father stop acting as her conservator. My question in all of this, before we get into the rest of what Jodi Montgomery said, is this can't be new. Like, we know this isn't new. So what was Sam Ingham doing? Because this isn't new information. Why was no one listening to Britney when she was saying this years ago? I'm glad someone's listening now, but also frustration. Montgomery's declaration concludes that, quote, in my opinion, Dad Spears' removal as conservator is critical to Britney Spears' emotional health and well-being and is in the best interest of the conservative. Interested party Lynne Spears has similarly declared under penalty of perjury that during a critical period from 2018 to 2019, Dad Spears, quote, had absolute control over the conservative's money and her healthcare decisions. She further declared that Dad Spears approved treatment from a, quote, sports enhancement doctor who prescribed Britney Spears medication that seemed, quote, entirely inappropriate and, quote, compelled Britney Spears to enter a health facility against her wishes. Lynne Spears described Dad Spears' microscopic control over Britney's actions, resulting in an environment with all eyes on Miss Spears. Quote, such scrutiny is exhausting and terrifying, like living in custody. Well, yeah, that's exactly how Britney described it. According to Lynne Spears, the relationship between conservatee and Dad Spears has dwindled to nothing but fear and hatred of Dad Spears by the conservatee due to Dad Spears' behavior, including his complete control over her, his mistrust of her, his coercion of her, his bartering with her over what she can and cannot do for whatever reward or punishment he is willing to mete out, his constant threats, and his decision-making over all aspects of her life, which is what we heard Britney say in court, that he was on this like dog training reward and punishment system where it's like, if you're a good girl as a grown-ass adult, doing what I have told you to do, then maybe you can see your kids and your boyfriend and have a life. That's not it. No, no, you don't get a cookie for being a good girl. You treat an adult like an adult with rights. You're not potty training like, a 1.5-year-old with M&Ms here, Dad Spears, which probably shows his own personal growth development capacity for emotional intelligence and ability to deal with someone who, disagrees with him about how they should live their own fucking life. But we'll continue. Lynne Spears also describes in her declaration a physical altercation between Dad Spears and the conservatives' minor children. This is what resulted in a restraining order that Kevin Federline filed to keep Dad Spears away from Britney's children. And this is when he had health issues and stepped down as conservator of the person. But remember, he stepped down temporarily. He is still blocking Jodi Montgomery being the permanent conservator of the estate. If something happened, or of the person, if something happened to Jodi Montgomery tomorrow, then he would be in charge of both the estate and the person again, because he only relinquished his power temporarily, which says a lot. The physical altercation between Dad Spears and Britney's minor children, as appalling and inexcusable, which understandably destroyed whatever was left of the relationship between them. Yeah, you touch my kids, it's not going to go well. It's not going to go well. And if there is an interaction like that between his grandchildren, I can imagine, and I would not be surprised if that was also the case with his own children. Finally, aptly summarizing the controlling issues before the court, Lynne Spears' declaration concludes as follows. It is clear to me that James P. Spears is incapable of putting my daughter's interest ahead of his own on both a professional and a personal level, and that he is being and remaining a conservator of my daughter's estate is not in the best interest of my daughter, the conservatee. Removing Dad Spears from his post as conservator of the estate is in the best interest of Britney Spears. Since receiving professional medical care at the outset of this conservatorship over 13 years ago, Britney is clearly in a different place now, and she has been for many years. The entire world has witnessed Miss Spears working tirelessly with astonishing dedication, precision, and excellence as a musical artist and performer, an exceptional earner. Because with a kid on my hip, I'm still an exceptional earner. I'm not even going to try to sing Britney because I cannot. I cannot, not well, just in my car. I like that exceptional earner. Between toxic and exceptional earner, does it feel like Rosengart, or at least one of the attorneys working for Rosengart, is pulling some languaging from Britney's music? Because I feel like it is. Maybe it's just me. Am I reading into it? Chat, you have to let me know. Am I reading too much into it? Because I feel like this is an homage to Britney. I do. An exceptional earner from Mr. Spears and others who had a financial interest in making sure she would continue to work and perform. For example, since this conservatorship began, Britney has released 4 albums: Circus, Femme Fatale, Britney Jane, and Glory. Miss Spears also headlined hundreds of shows that grossed hundreds of millions of dollars, including 97 shows for the Circus tour, in gross revenue of $131.8 million, 79 shows for the Femme Fatale tour, resulting in a gross of $68.7 million, 248 shows. Jesus, that's a lot of shows. For Piece of Me in Vegas at $137.7 million, 100 shows for Britney Live in Concert International Tour, revenue unknown, 31 shows for the Piece of Me tour, resulting in a gross revenue of $54.3 million. All tour revenue numbers are from Polestar. So those are estimates, but they're estimates, but we'll see. Missy says somebody at the lawyer's office is a Britney fan and is using her lyrics. I think so too. Previously, perversely, not previously, Emily, language. Perversely, all this time while performing extremely well, hard, and meticulously, and earning substantial revenues for others, Britney has had no control over what contracts were signed on her behalf and what those contracts would commit her to do or perform. We've talked about this too. This is one of the most dangerous things about this conservatorship. There are many, but the fact that Dad Spears got to pick the contracts, negotiate his deals, and then he got to approve them. There was no checks and balances in this. Worse, it goes on to say, all the above was without regard for what she, the talent, the breadwinner, and the star, and the conservatee, wanted to perform at all. Her best interest is the governing principle here. The court heard Ms. Spears' powerful and poignant testimony on June 23rd, when she described an instance in 2018 at a time when she was unable to select her own attorney, where she felt intimidated and threatened to perform on tour. Britney also described how after the 2018 tour canceled, she was contracted to perform in a new Las Vegas residency, notwithstanding her desire for a break from the tireless work she had previously performed. As Spears testified, quote, "I'd been doing Vegas for 4 years and I needed a break in between." I mean, it's fair that you might want a little time to yourself. But no, I was told this is the timeline and this is how it's going to go. And when Miss Spears, a highly experienced and brilliant entertainer, dancer, and choreographer, Fred, not now. No. Please stop knocking things off my desk. Fred, we're talking about Britney. We can't be knocking things off the desk. Thank you. You can sit, over here. Sorry, paw nerd interruption. And when Britney, a highly experienced and brilliant entertainer, dancer, and choreographer, decided during rehearsals that she would not perform a particular dance move requested of her, she was rebuffed by those, quote, in charge, who responded by calling Miss Spears now deceased therapist and accusing Miss Spears of not cooperating. Quote, this is what Britney said in court. My manager called at that moment and told my therapist I wasn't cooperating or following the guidelines in rehearsal. And he also said I wasn't taking my medication, which is so dumb because I've had the same lady every morning for the past 8 years giving me my same medication. And I'm nowhere near these stupid people. It made no sense at all. In that part of her testimony, she was talking about how she didn't take medication during the day, so they wouldn't know she was or was not, because that was not during rehearsals. That was in the morning. Thereafter, when Miss Spears advised that she did not want to do the Las Vegas residency, she was again accused of not cooperating. She testified, quote, "My therapist sat me down in a room and said he had a million phone calls about how I was not cooperating in rehearsals, and I haven't been taking my medication. All of this was false." Her doctor immediately put her on lithium, a dangerous and extremely powerful drug that the National Alliance of Mental Illness describes as a mood stabilizer medication. They said, i.e., a powerful cooperation inducer that, among other more serious side effects, is known to cause severe nausea, vomiting, hand tremors, confusion, visual changes. I wasn't trying to click the link. Vision changes and unsteadiness. Miss Spears had not taken this drug before. The message Miss Spears received from her father was clear. When she said no, she had no control or autonomy, and she had to do as she was told, or else she would once again be deemed, quote, uncooperative and be further medicated against her wishes. Indeed, throughout this course of conduct, Mr. Spears stripped his daughter of her dignity, including her dignity to make her own decisions, and of her humanity. In her June 23rd testimony alone, Spears has described the impact of her father's control as feeling forced, threatening, and scary. She also testified due to her father's role in her life as conservator, she felt traumatized, could not sleep, cried every day. Underscoring her father's role, his detrimental involvement in her life, and the need for his prompt removal, Ms. Spears also testified that her father enjoyed her crying on the phone with him. He loved the control to hurt his own daughter 100,000%. He loved it. And that was from her testimony on June 23rd. In short, Britney has perceived and described the status quo as traumatizing, insane, and depressing. Regardless of whether Dad Spears contests his daughter's testimony and perception of the status quo, Britney Spears' testimony is genuine and makes clear that Dad Spears' continued presence as conservator is not in her best interest. No shit. They also go into the conservatorship of Navarrete. That's a different case, saying adult conservatee could not be forced against her wishes to have a relationship with her father, regardless of whether conservatee's allegations of abuse committed by the father against her were true or false. They're saying it doesn't matter. We don't have to do a fact-finding mission. We don't have to prove, nobody has to prove whether this is Britney's perception. She feels traumatized. Nothing more needs to be said. Nothing needs to be proved. There doesn't need to be any evidence. There's no claims to refute. What is in her best interest is based on how she sees things and how she feels. Therefore, there should be no fact-finding. It's removing him because that's what's in her best interest, based on all of her statements, the medical team statements, and others. So they're pointing out to the court again, if Dad Spears comes in and is like, well, we need a fact finding on all of this. No, it's irrelevant. What's the most relevant is that Britney feels scared. Britney feels threatened. So it can't be in her best interest. Those are her feelings. What fact finding mission are you going to do about her feelings? That's how she feels. That's it. This conservatorship has been described by some as voluntary. Well, that's how it's indicated on the court documents. But the court heard Ms. Spears' testimony that she was unaware she could petition to terminate the conservatorship this entire time. This conservatorship has also been described as unique in that Britney Spears is an obviously highly functioning individual. The fact that Ms. Spears functions so well, as demonstrated to the entire world, while she made music and performed, generating joy for her fans and jobs and income for countless others, is antithetical to the notion that she needs to continue indefinitely to be subject to a conservatorship, as she has been under now for the past 13 years, which is supposed to be a last resort, a conservatorship. That is being the last resort. As noted above, this is not the issue present before the court, like the issue of whether affirmative claims are pursued against Mr. Spears for misconduct. The ultimate resolution of the issue would potentially be for a later petition at a later date. Again, reminding the court, all this shit exists but focus on the issue, and not just reminding the court, I think, but reminding everyone that yes, there is all of this going on. There is a big world out here. We are focusing on this one small issue, and the one small issue that's being focused on in this petition is what's in the best interest of Britney. That is no longer her dad. Yeet. It's a lot of pages to say that, but still. To be clear, this petition focuses solely on relief to remedy the most pressing issue facing Ms. Spears, removing Dad Spears as conservator of the estate and replacing him with someone who's actually qualified. I read into that. There's a lot more words to say that. I read into that. That was my opinion that Dad Spears is not qualified. That doesn't say that in this document. It alludes to it strongly. It goes on to say there can be no question that the relief requested here is in Ms. Spears' best interest, which as a matter of law is the only relevant consideration. The relationship between Ms. Spears and her father is so fractured that Ms. Spears and her father do not even speak. Any interaction with her father is unwelcomed and needlessly stressful for her. Ms. Spears, and this is an awkward sentence, who is referenced above. Britney, who testified that she's fearful of her father, along with many reasons for that fear. Furthermore, Spears previously informed this court through prior counsel she will not resume her career and perform again so long as her father's in charge. Exhibit D, November 10th, 2020, hearing transcript, page 32. The venomous nature of this relationship makes Mr. Spears' prompt removal under Section Code 2650 inexorable, and it is detrimental to the well-being of the very person the conservatorship is supposed to protect. Indeed, far from benefiting Ms. Spears, as she herself has testified, it impairs her mental health, her well-being, and her ability to pursue and continue with her extraordinary career. It's very interesting to me that that's in here because they are alluding to and would have had conversations with Britney about what her future plans are. This does not allude to the fact that she's retiring. This alludes to the fact that she would like to get on with her career if her dad's not involved, which is, I don't know, nice to see. Even in the context of a trust where, unlike a conservatorship, the legal standards are entirely deferential to the trustees appointed by trustors, such hostility would still support the fiduciary's removal, which again, not the situation here, but even in a different situation, this situation is out of control, is what they're saying. Significantly, and as referenced above, Britney's position is supported by Jodi Montgomery, the conservator of the person, as well as by her mother. Finally, Dad Spears' attorney has stated that Dad Spears contests certain unidentified aspects of Britney Spears' recent testimony and wishes to defend his character against charges made. It's irrelevant. And you're just spending Britney's money to do it. They go on to say that would be highly inappropriate. And moreover, it is irrelevant for the purposes of this petition. As a matter of law, a conservator's opposition to his removal, motivated by self-interest in defending his reputation, is not in the best interest of the conservatee. Say it louder for the people in the back. I'm sorry if that was excessively loud on my mic. Apologies to everyone watching with headphones. But yeah, we'll go back to snapping. I'll go back to snapping. Yes. That would be highly appropriate. Highly inappropriate and is irrelevant. As a matter of law, a conservator's opposition to his removal, motivated by self-interest in defending his reputation, is not in the best interest of the conservatee. Neither is spending $500,000 in legal fees on media matters to protect your hurt feelings. Indeed, Mr. Spears should also be aware. Warning. The former prosecutor is telling you what you need to be aware of, Dad Spears. Shots fired. Mr. Spears should be aware that any fees incurred in such an endeavor may not be paid from the conservatee's estate. See Conservatorship of Lefkowitz, holding that a conservator's fees and attorney's fees incurred to oppose petition for removal were incurred solely to protect the personal interest of the conservator, i.e. to defend character and reputation, and therefore were not payable from the estate. Boom. That's Rosengart saying, by the way, H&K, James Spears, all y'all, we're also coming for the money. Just don't you worry about it. You go ahead and you do what you think you're going to do. We're going after the media matter money that's already been objected to, but we're also coming for the money. So don't think you're going to spend Britney's money to do this. Be on notice. In short, for these present narrow purposes, all that matters is what Miss Spears's, not her father's, what is in her, what Britney, not her father's best interest. Mr. Spears, this is just, we're gonna womp on Mr. Spears a little bit more. Good. Mr. Spears should be supportive of his daughter's request to remove and replace him with a professional fiduciary. As a fiduciary, Dad Spears is obligated to accommodate her requests that he step aside and let a professional take over his current post. Probate Code Section 2113 provides a conservator shall accommodate the desires of the conservatee, except to the extent that doing so would violate the conservator's fiduciary duties to the conservatee or impose an unreasonable expense on the conservatorship estate. If your conservatee comes to you and says, I want to build a spaceship to Mars, you may be able to say, I think we'll leave that to like Elon Musk and Jeff Bezos. Maybe that's not within our purview. But other than that, it would be hard to think of a unreasonable expense. They go on to cite other law standing for the same proposition. They say here, Dad Spears is not accommodating this petition, either by not opposing or voluntarily resigning. Why? Why is this hard for me today? It just is. Here, Mr. Spears accommodating this petition, either by not opposing or voluntarily resigning, would not violate any fiduciary duty, but would rather fulfill his fiduciary duty by doing what is plainly in the best interest of his daughter's health and well-being in order to avoid further harm and injury to her mental health. So they en-routed the anticipated argument from Dad Spears' team, like, no, we're a fiduciary, we can't just resign. Well, Ingham has an obligation to her too, and he resigned. Bessemer had an obligation too, and they resigned. You can also resign. You can. And I like that they end-routed that argument, knowing that that's what would come up. It's like, oh, but we can't. It's our duty. No, it's not. It's here. We've covered it for you. Don't you worry. We've made it clear by citing case law that the relationship between a conservator and conservatee is a fiduciary relationship. Any decisions affecting conservatee's health must be made in a manner consistent with the conservatee's instructions and wishes to the extent known, or failing that in furtherance of the conservatee's best interest. They go on to say, nor would Dad Spears acceding to this petition, again, either by not opposing it or by voluntarily resigning, impose unreasonable expense to the estate. Oh, they're end-routing argument number 2. To the contrary, unlike Mr. Spears, well, if professional financial... the shade. You're not a professional, Dad Spears. To the contrary, unlike Mr. Spears, while a professional fiduciary will be required to furnish a bond in the same amount as Mr. Spears, a professional fiduciary will charge solely for the hours worked and not pay themselves in a lavish fashion enjoyed by Mr. Spears. Yeah, you don't get a salary. You just bill for the work done, which at the beginning might be more expensive because there's going to be a forensic audit, but then should be less. You don't just get a lump sum to just do whatever. Finally, perhaps most importantly, for the purpose of obtaining the immediate relief necessary, this court is not at this time being asked to adjudicate the wrongdoing on the part of Dad Spears. All Dad Spears is being asked to recognize is that 1, his daughter's best interest must be placed ahead of his own. No shit. 2, whether he has done an exemplary job, failed as a fiduciary, or worse, his mere presence as a conservator is detrimental to the well-being of his daughter. 3, accordingly, he should step aside in favor of a highly respected fiduciary nominated by Britney. In any event, regardless of whether Spears resigns voluntarily, as he should do immediately, this court should remove and replace him for these very reasons. Conclusion: in sum, Britney's best served by yeeting her father. They're asking the court to grant an order removing James, revoking his letters of conservatorship. Should he contest his petition for an order suspending him as conservator of the estate and replacing him as an interim conservator of the estate, for an order directing James Spears to prepare and file a final accounting and to surrender the estate to the successor So they're saying if he objects, if he contests, then the court should immediately suspend him, because they've laid out in this petition and put both him and the court kind of in, well, the court in a position to say, this is why this needs to be granted. Here's all the law. Here's all the support. But it's put Dad Spears in a position where if he objects to protect himself, it shows that he's acting in his own interest and not in the interest of the conservatorship, and saying to the court, if he objects, suspend him or let him resign. It's kind of like when you get pulled in at work and it's like, you can choose to resign or we can fire you. That's the position that James Spears is in right now. And it's not going to make anything better down the line for him, because either way, no matter what happens, they are going to continue looking into him. If he chooses to resign, this isn't over. If he chooses to object, this isn't over for him. This is step one of going after Dad Spears the way Britney asked to. This is signed by Britney. I, Britney Jean Spears, am the petitioner in this proceeding. I have read the foregoing petition and know the contents thereof. The facts stated herein are true of my own knowledge, except to those matters that are alleged therein on information and belief. As to those matters, I believe them to be true. I declare under penalty of perjury. Signed on the 24th, signed by Britney. This is the nomination that's attached to the other one. So that was a 24, as we see in this one. This is the same attached to the other one. Exhibit A is the Declaration of Jodi Montgomery. Let's get into the Declaration of Jodi Montgomery. I'm going to timestamp that. Thank you all for hanging with me. I know it was a long motion to get through. I had a lot of thoughts. Declaration of Jodi Montgomery. I've been a professional fiduciary since April 2011, certified national guardian, license numbers, standing, licensing, all the stuff. On August 21st, 2018, I was retained by Dad Spears in his role as both conservator of the person and co-conservator of the estate, as well as by Andrew Wallet, co-conservator of the estate, to serve as a case manager for Britney Jean Spears. As a case manager, I assisted Dad Spears in his role as conservator of the person on an as-needed basis and in the best interest of Britney Spears. I served in the case manager role until I was appointed by this court as temporary conservator, September 9th, 2019. My letters of temporary conservatorship of the person have been continually renewed since my initial appointment and are set to expire October 8th, 2021. There is a current pending petition by Dad Spears to appoint me, by Britney Spears to appoint me as general conservator of the person so I can permanently replace Dad Spears as conservator of the person, although Dad Spears has yet to execute the resignation of his role of conservator of the person, which we've talked about at length. It goes through her roles as to what she does. She helps vet and put together a medical team, including primary doctor, psychiatrist, personal coach, a coach for her visits with her children and other needs. Throughout her almost 3-year tenure as a case manager and temporary conservator of the person, she's worked closely with Dad Spears in fulfilling her duty to Miss Spears. Over the last almost 2 years as temporary conservator, I've also worked closely with Britney and with Britney Spears' medical team, as demonstrated by Britney Spears' recent testimony to this court. Britney has serious unresolved issues with her father, Mr. Spears, sourcing back to her childhood that cause her great distress and emotional upset. This distress and upset is genuine and real. During my tenure, I have personally observed dynamics at play between Dad Spears and his daughter, Britney, that are not psychologically healthy and supportive for Britney and her mental condition. The conservatorship's main focus should be Britney's best interest, happiness, well-being, and safety. It is my strong opinion and recommendation that the person serving Miss Spears' conservators not be family members. Instead, it is in Britney's best interest that only qualified neutral professionals and corporate fiduciaries serve as her conservators. I have numerous ongoing conversations with the medical team, and we all agree it's in the best interest of Britney and her well-being and mental health that her father stop acting as her conservator. I've asked Mr. Spears to consider stepping down. In my conversations with him, I told him he needs to go back to just being Britney's father, working on a healthy, supportive father-daughter relationship. In my opinion, Dad Spears' removal of Britney's conservator is critical to her emotional health and well-being and is in the best interest of conservatorship. Again, why this took so long is concerning to me, as it is to everybody. Declaration in support of removal by Lynne Spears. I am the mother of Britney Spears and an interested party in this matter. I submit this declaration to support the removal of Dad Spears. I have been a participant in this conservatorship as an interested party since May of 2019. Since May of 2019. She didn't come in as an interested party until May of 2019, which means Lynne Spears had no direct involvement with this conservatorship until May of 2019. Didn't know what was going on unless it was told to her by someone else. I became involved in this conservatorship during what I will term a, quote, time of crisis that began at the end of 2018 and continued into 2019. I became involved in this conservatorship because I wanted to ensure that everything in my daughter's life was handled in the best interest of my daughter, the conservatee, which I did not believe at the time and still do not today to be the case. At all points of time during this time of crisis, just call it what it is, Lynne. Dad Spears, her father and sole conservator of the estate, and at the time the person had absolute control over her money and her healthcare decisions. At the quote time of crisis, my daughter, the conservatee, was being treated by a sports enhancement doctor hired by Dad Spears. The doctor in question was a psychiatrist who was prescribing what I and many others thought to be entirely inappropriate medication to my daughter, who did not want to take the medication. During the time of crisis, I witnessed my daughter be compelled by that doctor, with the knowledge and encouragement of Dad Spears, to enter a health facility that she did not want to enter, where she was threatened with punishment if she did not stay for medical treatment that she did not want to endure. At all points of time during this time of crisis, Dad Spears had the knowledge of the entirety of the circumstances because he was approving and paying for all of her expenses, and he has since the inception of this conservatorship. Throughout this conservatorship, Dad Spears has exercised absolutely microscopic control over the conservatee and her actions. Dad Spears has relied on members of the conservatee's household staff, medical aides on site at the conservatee's home, and her own security detail to inform on and report back to him each and every detail of every action that takes place in her home and in her life. Such scrutiny is exhausting and terrifying, like living in custody. Yeah, he terminated, based on other reports, the people that she cared about and chose for herself, and placed snitches in her home to inform on her. And some reports indicate cameras in her home as well. To not have any place of sanctuary is beyond horrifying. No wonder Britney feels traumatized. It's such an absolute violation of privacy. It's so far beyond the bounds of what should be happening in any conservatorship. Since this conservatorship has been in place, the relationship between the conservatee and Dad Spears has dwindled to nothing but fear and hatred of Dad Spears by the conservatee due to his own behavior, including his complete control over his mistrust of her, his coercion of her, his bartering with her over what she can and cannot do for whatever reward or punishment he is willing to met out, his constant threats, and his decision-making over all aspects of her life. All of the actions that solidified the failure of my daughter and Mr. Spears' relationship, the physical altercation between Mr. Spears and the conservatee minor children, my grandchildren, was perhaps the most appalling and inexcusable, and understandably destroyed whatever was left of a relationship between them. It is clear to me that James Spears is incapable of putting my daughter's interest ahead of his own on both a professional and personal level, and that his being a remaining conservator of my daughter's estate is not in the best interest of my daughter, the conservatee. I declare under penalty of perjury. Yeah, that puts a pin on it. This is attached the transcript from the June 23rd hearing, which we've already seen. I'm going to scroll down a little bit because the other hearing is in here. And we've gone over what the court ruled at that hearing. We did not go over what Britney said at that hearing, other than reports from those that were inside the courtroom, because it was not in any way distributed. Exhibit D is the November 10th, 2020 hearing, wherein they asked to remove Dad Spears. Let me just look real quick at this. I have not had a chance to go through these yet, and I will and pull out any little nuggets because I have a plane ride to do that on. But this is where they are talking about the finances and then trying to bring in Bessemer. I'm trying to find where it says they want to remove him, but it's in here that she doesn't want to perform. She wants him removed. That's been widely reported. I'll highlight it and share it on social in the next few days there, because I don't want to waste y'all's time, because we have more to get to. Here's his statement. Here we go. Here's his statements in November. These are Ingham's statement. He said, so in the time between January and October, we have 5 different responses to, or 4 different new responses to my client's simple suggestion that we plan to bring in a corporate fiduciary. This is Dad Spears kicking and screaming in November 2020 over them bringing in Bessemer Trust. None of these plans were discussed with me or with my client. And most importantly, none of these plans address my client's wish for simplicity. My client is not performing. It is still questionable to me whether she needs to have a business manager. That was Lou Taylor before Lou Taylor resigned. But that is something that that could have been discussed, as could have Mr. Keene. But instead, Mr. Spears simply acted unilaterally to throw these different ideas before the court, hoping that one of them would stick. So then we arrive at the response to Miss Thoreen, which we filed and served last Friday. The response, I'm pleased that Miss Thoreen recounted it as well as she did. She did a very good job of encapsulating the substance of the response, and the very words that she used to explain her client's position also explained why it is, this is problematical. This actually says problematical, not problematic, problematical. Did Sam Ingham say problematical in court? It is problematic to Britney and to me. We hear words like, quote, Mr. Spears has full authority to act. Mr. Spears is not obligated to give notice of resignation of TriStar. Mr. Spears is not obligated to consult with Mr. Ingham with regard to the appointment of a new business manager, end quote. Leave aside for a moment the fact that the business manager is intimately involved with my client's career activity. The notion that a conservatorship should function from a top-down fashion, quote, I'm the conservator, I have the badge, I make the rules, and I don't have to tell anybody what I'm doing. And if I'm doing what the code permits me to do, end quote. It is certainly inconsistent with the way this case was handled up until a short while ago. And his statement that changed makes me wonder what changed with the way Dad Spears was behaving, or if Britney had been consulted at all. And in the indication of a high-functioning conservative like my client, it is simply not appropriate in the situation, maybe. Then we get to the real crux of Miss Thoreen's response. Miss Thoreen's the lawyer from H&K. There are 2 items in it that I find really intriguing. I found them offensive if he's going to say what I think he's going to say. The first is a footnote in which Mr. Spears has said, quote, Mr. Spears vehemently denies that he has had any disputes with his daughter, Britney, despite Mr. Ingham's assertions, end quote. Your Honor, oh, not end quote. Your Honor, I've been married 34 years and I am now speaking under oath. Oh, no, that was back to Ingham, end quote. Your Honor, I've been married 34 years and I am now speaking under oath. If I were to tell you that I have no disputes with my wife, vehemently to tell you that, you could probably have me arrested for perjury. Every relationship has problems. Every relationship has problems. If Mr. Spears had said, quote, it's tough being conservator for my daughter, but all in all, it's working out. We're doing our best and we'll work through things. Thank you very much, Mr. Ingham. I could accept that. But to vehemently deny that there are any disputes is simply not credible to me or to anyone, Sam Ingham, or to anyone. And from there, we get a further statement, which is even more interesting. This is the motion where Dad Spears hired a new business manager without telling anybody and was like, I don't have to give anyone notice. I do what I want. It was very Cartman of him. The response says that, quote, query whether that is truly what the conservatee wants or if it is in her best interest for herself. When I read that, this is Sam Ingham now stating, I started working myself into a high judgment, but then I stopped and I realized for a second, wait a minute, Mr. Spears has to play the cards he has. And that's really pretty much the strongest card he has, because if what I'm saying about my client's state of mind, my client's wishes is correct, he has been in deep trouble as conservator. So here's the bottom line. This is still Ingham speaking. I am seeking today as an officer of the court, and I have been sworn, and I am stating that my client has informed me on many occasions that she is afraid of her father. She has also informed me on many occasions that she will not perform as long as her father is in charge of her career, and that she also informed me that she does not want her father to work with Bessemer Trust. So we are now really at a crossroads, like the Britney movie. We have the ability to bring back in a new conservator who, despite a little bit of backpedaling by Miss Thoreen, has not been objected to by her client. From my point of view, and the conservatee's point of view, the loss and injury comes not just from the risk that I mentioned in terms of the objections, but a conservatorship in which the conservator and the conservatee have no viable working relationship. My client has not spoken to Mr. Spears in a long while, and it is not a recipe that is viable for from my conservatee's point of view. We have a chance to make a fresh start with a new corporate fiduciary. I certainly have no desire to weigh a heavy hand on what they do. I think that Bessemer Trust is ideally suited to work with my client's entertainment team and to continue her financial stability. And finally, I would just like to say, this is a voluntary conservatorship. As long as my client's choice of conservator is reasonable, I think she should be allowed to work with a qualified corporate fiduciary of her choice. And I think that the path we've gone through the entire summer with acrimony and repeated alternative suggestions from Mr. Spears simply demonstrate that the existing agreement is not satisfactory. It does not present risk to my client, and that to continue with Bessemer and this locked in with these two, Mr. Spears and Bessemer together, I think it may well. I agree with Ms. Thoreen's statement. She said there's no dispute between Bessemer and Mr. Spears, and then it goes on. But that was Ingham talking about the fact that Britney was having issues with her father and was made very clear to the court in 2020. And at that time, I don't know if it's because Ingham didn't focus back on the best interest of Britney, but at that time, the court refused to remove Jamie Spears. And I hope that the court has rethought that and has some time to see it from Britney's point of view. And those are the two, I thought there was another one attached, but I don't see it. So I will go look. That might have been attached under seal. I'll go look for the last court, but this is the 120. No, this is, all 127 pages. That was the 12th November 2020. So I will go back and look for the other one that was quoted, but that is the end of the petition. I am going to real quickly sweep the Girardi updates, but we don't have time to get into them because I've been live for an hour and 30 minutes. Oh my God, you guys, this is a lot. Cat, what are you doing? It's always you. It's never your brother. It's always you. Sorry for the paw nerd that just. Yes, you can hang out. Yes, you can. That was a lot. So we are going to sweep quickly the Girardi stuff that's going on. So let's do that. Let me mark it down. We're at 137. All right, let's do a quick Girardi sweep because new stuff has happened. And then we will get to all of the questions. Quick Girardi sweep. First of all, in the Lion Air case, they are still pursuing. That is the case that kind of tipped this all off with Edelson PC. They are still pursuing other attorneys from Tom Girardi's firm, Girardi Keese, for contempt. One of them is his son-in-law. What is happening now is that those attorneys are like, we can't come in on contempt proceedings because we don't have access to the records. So the court in Illinois has ordered that the records be turned over and that the bankruptcy trustee for Girardi Keese allow the other attorneys to have access to those records so they can defend themselves. They were trying to be like, let's wait till the bankruptcy is done. And the court's like, no, that's not what we're doing. We're moving forward either way. So they are going to have to give over discovery in those contempt proceedings because, again, the proceedings are stalled as to Tom Girardi. But as to other attorneys at Girardi Keese who were on the Lion Air case, the court is moving full steam ahead dealing with the issues there. Also, we have been undergoing fights with the lawyers. I'm sure you have seen stuff on Twitter. Hold on, let me pull up Twitter real quick. Let me go to the tape. Just kidding. Going to the Twitter. We're going to the Twitter. Erika has had quite a lot to say on Twitter about lawyers. I think this might have been relating to something else too. Can all the lawyers on here commenting please do something productive like bill your clients? You guys saw what I had to say about it. I had thoughts. For sure. But Erika coming for the lawyers on Twitter, she did that quite a bit. She went after Ron Richards, went after the law school he went to, went after a whole bunch of other stuff up on her Twitter. She is definitely having a moment. I don't know where the other ones were, but she was definitely having a moment talking about Ron Richards. So this was, Richard's tweeting something. Hi, no filter, Zach. We talk about that on his podcast. I think it's coming out on Friday. We talk about this tweet. Ron Richards retweeted a meme from a while back, but Ron Richards is directly, Erika's attorneys say directly commenting on Erika. And we know that there have been motions from Erika's attorneys to remove Ron Richards as the special prosecutor for the bankruptcy estate. He is going after Erika for, in the first lawsuit, $20 million, going after depositions. Erika's attorneys have responded. This is their reply memorandum in support of the motion for reconsideration. They are still trying to yeet Richards off of this case. They have had quite a lot to say about it. They have talked about the fact that since the filing of the motion and their quick introduction, the circumstances of unethical and prejudicial extrajudicial statements by current counsel for trustee, Mr. Richards, have gotten significantly worse, specifically after filing an adversary complaint against Mr. Girardi on July 14th, 2021. That's the $25 million lawsuit in here. That's the adversary complaint. And an opposition to the motion on July 16th. Richards has engaged in debate with and attacks on Ms. Girardi, a represented party, in several Twitter posts on social media, including on the merits of his recently filed adversary complaint. Such direct engagements by an attorney with a represented party violate Rule 4.2 of the California Rules of Professional Conduct. They diminish the integrity of proceedings before this court. They have caused prejudice to Girardi, and they provide more grounds for this court to vacate its prior employment order. Only this court can provide remedy at this time. They're arguing again that whatever back and forth is happening on Twitter is actual conversation between the party. In a statement to, I believe it was Law 360, Richards denied that and said, I didn't DM her. Well, they're going to argue that at tweeting or quote tweeting or responding in that way is a problem. Richards is going to argue that he is not having direct discourse. He is having open discourse on a social media platform. They say since filing this motion, Ms. Girardi, through current counsel, has cooperated and assisted with the production of documents and information to the trustee. Given the trustee's choice to file an adversary proceeding against Girardi, the trustee's discovery rights under Rule 2004 are now replaced by a requirement following the federal rules of civil procedure in the adversary proceeding. Nonetheless, Girardi has every reason, and it is in her interest, to bring forward all relevant evidence. So again, they're going on about the Twitter, notwithstanding the protestations of the multiple and duplicative opposition filed by Mr. Richards and the trustee, including inadmissible, legally inaccurate, and wildly argumentative expert declaration. The following points remain undisputed, according to Erika's attorneys. Again, allegations. Nowhere in the opposition papers nor in his declaration does Richards or anyone else deny that. In fact, the Twitter and social media communities attached in this motion were his words and statements. This includes his statement, nowhere mentioned in the supposed expert declaration, that Mr. Girardi hopes that Ms. Girardi continues to be represented by counsel in this case, quote, because he doesn't think her personality is consistent with compliance in a court setting. See Motion 1, Exhibit 1, citing YouTube interview June 16, 2021 at 11:02, 11:42. That is the Up and Adam interview. This statement constituted a direct and prejudicial attack on the integrity of an adverse party, Ms. Girardi, in violation of Rule 3.6, they say. Richards, as an attorney, granted the optional privilege of representing the trustee. The circumstances have only become more dire, as demonstrated by the license that Mr. Richards believes he had after filing his adversary complaint and opposition papers to engage with an adverse represented party, Ms. Jodi, on social media about the matters in dispute before this court, including the merits of the adversary complaint. Well, what did he say? Tell us what was said. The First Amendment rights of an attorney, including and especially one representing a bankruptcy trustee, are constrained by the rules of professional conduct. Yes, we know, but what was said is what we want to know. Mr. Jodi understands that the trustee's investigation and mutual disclosure of the parties of all relevant evidence in an adversary proceeding are inevitable. It is not Mr. Jodi's intent to impede the trustee. If the trustee were concerned about prejudice due to having to replace Mr. Richards, the trustee would have to put a stop to his prejudicial and tawdry social media campaign. Tawdry feels like such an old-timey word. After the motion was filed, but this did not occur. Many attorneys are and would be capable of concluding the trustee's investigation, and if the adversary complaint is in fact supported by evidence, prosecuting it. They go on to say, finally, and contrary to the erroneous statements of Mr. Richards, quote, expert, based on Supreme Court precedent, Ms. Girardi indisputably has the right to a jury trial on the trustee's fraudulent conveyance claims. Yes, she does. In the recently filed adversary complaint. We talked about that previously, that she does have a right to trial inside of the bankruptcy court, and pretrial publicity is the way that they're going with this. Richards is going with no standing. We'll see what the court decides. I just want to know what was said. This is their argument about the fiduciary duties and the law they think applies. They say the motion is procedurally proper. Girardi has standing. She is an equity interest holder by virtue of community property law in Tom Girardi's law firm and bankruptcy estates. I mean, it's a fair point and it's a true point. So she has standing to bring the motion. Richards was saying she doesn't have standing because she's not a creditor. They're saying because she has a community property interest in the law firm, she is a creditor and she has standing. Let's see what else they think she said, because they didn't say how he was engaging with her on social other than that comment in an interview, which is interesting. On July 17th, the day after filing his opposition papers, Richards responded with 3 separate postings to a post from Ms. Girardi about the new adversary complaint, in which she stated, no merit, no investigation, no proof, just more harassment. It is not an answer for an attorney, especially when he represents a bankruptcy case, to say that an adverse party spoke first as justification to engage directly with a represented adverse party on the merits of the pending. But this is precisely what Richards did. First, on July 17th, Richards tweeted in response as follows: no real cooperation yet, no production of documents yet, not allowing witnesses to speak because she hired her own attorney to intervene, no disclosure as to the source of hundreds of thousands of dollars being spent, no acceptance of firm liabilities, but objections to firm assets. And this is in their declaration. It will be interesting to see if he responded under her tweet or if he tweeted separately, because I think the distinction matters. Because if he tweeted separately, both sides are allowed to respond to the statements of the other. So Erika saying no merit, no investigation, attorneys are allowed to respond because that could be seen as a prejudicial statement against the bankruptcy trustee, and you're allowed to respond to those. So when I said earlier that I thought Erika tweeting about this could come back to bite her, the court could say, look, these are in response. You're allowed to make a response. That we saw that in the Without a Crystal Ball Toddy Westbrook case, that there would be things that would get tweeted and Saltz would respond on his own Twitter by either asking questions or kind of making statements, and you are allowed to respond. So their statement that Richards is not allowed to respond is not accurate. I don't always think this type of response is advisable, but he's allowed to respond. They say second, Richards posted another tweet containing images from what appear to be excerpts of a Girardi Keese tax return, as well as a statement of information filed with the California Secretary of State. In this tweet, Richards again posted in direct response to Girardi, but did he post it under her? Did he subtweet her, or did he tweet on his tweeter and say it? Because it's a difference. He stated, Merit, there are large checks for jewelry purchases. She has expensive jewelry. Investigation, the IRS lenders were told for years by their firm she has receivables old, i.e. EXH. I imagine there's an exhibit below. No consent to view accounts to see how they were capitalized. Evidence, not harassment. Third, Richard posted the images of two more documents, a letter to Girardi Keese on Girardi Keese letterhead, and an excerpt of a grant deed regarding property in the city of Malibu. He stated, statement per California Rule 3.6c, she is the sole heir unless this is a false statement to a lender. The community property includes the firm, aka the debtor. She is jointly owed assets in the marriage. See docs, grant deed, lender. The below tweet from Ms. Girardi does not change the evidence. So it doesn't sound like he was subtweeting her. It sounds like he was on his own account tweeting things in response to things she said, which if they're making statements that the court perceives to be about the bankruptcy trustee, he's allowed to do that. He's allowed to do that. They might not like the way he's doing it, but he's allowed to do some of that. So, again, this argument, though, goes to the fact that she has standing, too, because it says she's the sole heir, which means she does have standing in the case. So it kind of proves the point of standing as well. They say Richards' engagement with Girardi was not lost on the press, which reported on the above tweets as Mr. Richards clapping back at Girardi. See, Ron Richard claps back at Erika on Twitter and exposes Lisa Rinna's debt, available at... Who's in the video lottery today? Up and Adam, you're so popular. So popular in the Girardi lawsuit. So that is reported in the press on Up and Adam's channel. The lawyers are watching your channel, Adam. The lawyers are watching Up and Adam. Adding to a circus-like environment, Richards not only engaged with a represented party on the subject of a pending litigation, he also abused his position as counsel to the trustee to intimidate others who appeared supportive of Ms. Girardi. For example, after a former Real Housewives of Beverly Hills co-star posted a negative comment about Girardi, another co-star and friend of Girardi, Lisa Rinna, married to Hollywood actor Harry Hamlin, posted the following on Twitter in response. Oh, someone needs some attention. Okay, sweetie. This is regarding the stuff that was going on with Camille Grammer. See, Real Housewives of Beverly Hills prosecutor in Erika Jane's case goes after co-star Lisa Rinna. He is he's not really a prosecutor. He's a civil attorney, says the former prosecutor. He is the, special litigation counsel. And they attached Screen Rant. Mr. Richards promptly took to Twitter and threatened Rinna with an investigation into her financial affairs. We did a surface dive on Rinna. So far, same business manager, larger debt on home. Wonder what else we would find, but we will leave it at that. The press correctly interpreted Mr. Richards' comments as a threat being made by him in his capacity as, quote, prosecutor. And they attached the Screen Rant article. As a prolific Twitter user, 5, well-versed in the mechanics of this social media platform, Mr. Richards adds Mr. Girardi's Twitter address or handle to ensure he communicates to her directly. Thus, on July 17th, Richards posted the following on his Twitter account, including Girardi's Twitter address to ensure the communication went directly to her. Well, notified her it's not a DM. I mean, we got to be clear. He's atting her. I don't know how do you describe atting in a social media, in a lawsuit context? Like, Your Honor, he added her. I don't know how to explain that better. Pursuant to California Rule 3.6, we are requesting assistance in obtaining evidence and information necessary to determine the source of Erika Jane's legal fees and expenses. Mr. Richards directly engages with and communicates to Girardi on Twitter. Only continued. On July 19th, in response to a post from Girardi addressing false reports about a burglary in the home, Richard posted the following, again, including Girardi's Twitter handle. Quote, I spoke with my good friend at Just Plain Zach, who actually posted this. I told him that it was causing at Erika Jane to again falsely accuse us of publishing something we didn't publish. On the same day, in response to the posting from Ms. Girardi regarding a further false report being published about her on realityt.com, Mr. Richards again felt the need to respond to Girardi directly, even though Girardi's post was not directed at him. One, we never said anything about at Erika Jane to this publication. Why retweet a false headline to 426,000 followers? ? Richards also made multiple Twitter postings in an attempt to litigate the motion on the internet as opposed to before this court, while adding additional commentary that is nowhere in the record. Thus, as part of a blitzkrieg of posts. Really? Blitzkrieg? We went from jihad to blitzkrieg? Really? Stop it. Plethora, flurry, abundance. There are other words. Boomer. This is part of the blitzkrieg of posts. On July 17th, Richards posted his evidentiary objections to the declaration of Evan Borges filed in support of this motion, commented on Mr. Borges, and again copied Girardi's Twitter handle, tweeted her handle, to ensure his communication went directly to her. It's not a DM. It's a notification. It's different. Richards stated, we get along very well. Super great guy. I'm hopeful he will convince his client to authorize the withdrawal of an unfair and at this point meritless motion filed before he even knew me professionally. Oof. That's not a good take. I don't agree with all the tweeting. But those that's not a direct response to Erika. That's a lot of in the weeds stuff that is just, I don't know how the court's going to perceive that. While Mr. Richards compliments Borges, the tweet incorrectly insinuates, once again, directly to Ms. Girardi, that her attorney should be persuading her to withdraw the motion. Right, that is problematic. Again, a direct communication by Richard designed to reach a represented adverse party. That he's publicly commented on the proceedings on Twitter. These are similar statements, that his statements on Twitter go beyond simply announcing ongoing court proceedings. He's chosen to, they say, attack Ms. Girardi directly and publicly, make prejudicial statements about the proper outcome of disputed matters before this court. That is true. They quote, again, the reason for restricting a lawyer's ability to speak out on issues in a pending case is to control the release of information about a case, thus ensuring a fair trial. Failed to make required disclosures. This was in their previous motion. The court should issue a gag order in the alternative. And the court had declined to do that previously, but may consider it now. The court might consider this on the motion. This is Evan's signature. And Exhibit 3 seem to be screenshots of Twitter and this. So, okay, this is retweeting, not subtweeting. That it's different, and it's not. So whether the court sees it as a direct response or not is going to involve the court's understanding of the workings of Twitter, because that is a retweet. But yes, it is responsive to what she said because he's retweeting her, but he is not under her Twitter commenting. So two different things. That might be a distinction without difference for the court because it is a direct retweet. But again, the Richards firm has already objected to the evidence put in because they are saying, look, there's nothing that says how these were collected, how these were gathered, that they're accurate, that we know this is actually Ron Richards tweeting, et cetera, et cetera. So these are all the tweets there, that they are taking objection with and that they've shared. This is probably going to involve all of them and the Rina one, but I want to get to a few questions before we have to wrap. Thank you to the mods for hanging in there. The ring. This is the Rina tweet. More about the housewives. An email between somebody. We never said anything about Erika Jane to this publication. 2, the article doesn't even attribute a quote to us. 3, we sent a retraction request the minute we saw the erroneous headline 5 hours ago. Why retweet a false headline to 426,000 followers? He attached to the email that he says he sent. Thanks, Reality T, for deleting the inaccurate story. Mistakes happen. Glad it was corrected. it is peculiar why some people would still be leaving on their page a headline that when you press the link, you get a page not found. They're continuing on with the other tweets that they had issues with. Between, I don't know, people tweeting about stuff. The meme just spoke with my good friend Just Plain Zach. Hey, Zach. Welcome to having your handle in lawsuits. Achievement unlocked. This is the rest of those tweets. Ron Richards questions Erika $500K in legal fees with a link to a video from July 22nd. Declaration of Evan. Let's see how Evan compiled these. Attached here too as Exhibit 3 is a compilation of Ron Richards' tweets and images from his Twitter page regarding this proceeding and individuals involved in this proceedings. They are true and accurate depictions. How do you know, though? Evan, this declaration isn't doing it for me, my guy. Since the filing of Girardi's motion, Richards' Twitter following has grown to 16,000 followers and now has over 20,000. Okay, well, A, you didn't lay out why that mattered. And B, we've seen good declarations regarding social media. This is not a good declaration regarding social media. It doesn't lay out how Evan knows how Twitter works, how Evan compiled these tweets. The court could say, you know what? This is not sufficient. Also, this declaration that I pulled from Pacer is not signed. This was filed yesterday. The 23rd. This was filed last Friday. This is not signed. So, and then proof of service to everybody involved in the bankruptcy. The Richards firm has already filed an objection to these matters of evidence. The court might throw out the tweets. The court might not. The court might have a hearing. The court might rule on it. I will update you on social. Let's get into some questions. That was so long. I have questions. You have questions. We have questions. We're at 2 hours. We're gonna speed through some questions. If I don't get to everything, I am sorry. If I don't get to all the super chats, I am sorry. I wanted to cover those documents. I wanted to remind everybody that I'm covering Activision tomorrow. Don't forget to give the mods some love. So Angel DM, it is a fantastic point saying it needs to be said, Rosengart needs to call out the court because there is a reason why Jamie felt like he didn't have to give notice to anyone about what he was doing and who he was hiring. Calling out the court right now will not work in Britney's best interest. Rosengart's job is to achieve the goals of Britney's goals. His job is to work in her best interest. Calling out the court is not it right now. Calling out the court is not going to work in her favor. He needs to work with the court right now because there's going to be ongoing investigations, but he needs to work with the court right now first. So that is it. All right. I see Linda Marie's super chat. Thank you. Question, because law nerds want facts, not fuckery. Can you please invite Robert Barnes, legal court of public opinion person for Kyle Rittenhouse, on as a guest before November when the court will limit what tea Barnes can spill? I will go look into that. I have not kept up well with what Barnes and Viva are up to, but I will look into it. I always enjoy their content, and they do good breakdowns on their channel. I don't know what's going on with his representations or what clients he has or what he is limited in saying. So not aware, but I will look. All right, let me get to a few more of the super chats. Thank you all. Question, wouldn't the judge have to question the cost for media matters considering James' attorney Vivian appeared in the documentary? Yes. And there's objections to it. And I've covered that in other videos on the Britney playlist. There are objections from both Lynne Spears and from Ingham, and those will be taken up by Rosengart as well. Those aren't just like, oh, we're good. Those are being fought over, as they should be. So there's going to be a lot of fighting with regard to the money. Don't you worry. I just told Zach he's mentioned it. Yeah, I'll send him a screenshot later on today for sure. Question, do you know about Lisa Rinna now being sued? I do know about Lisa Rinna now being sued. It seems not to be totally wild. I'm going to cover that on an episode of The Emily Show, but it's a paparazzo company saying you used our images on your social and you're not allowed to. It's not a huge thing. It's a thing, but it's not a huge thing. Question, why does Erika want Ron Richards out so badly? Melissa B, I think pure speculation. I think she feels that he has unfairly gone after her on social based on these motions and that it won't give her a fair trial, and that somebody with inside knowledge of the case saying that on social can have undue weight and it can affect how she's perceived. And so I think they think it's affecting how she's perceived. But if he is off the case, then he's free to say whatever the fuck he wants on Twitter. Like, he's not even a party. He's not a attorney in the case, and he is free to go in more. Or it could be petty. He stands to make up to 45% of what he recovers from her. So if he's trying to recover 25 million and is going to make 45% of that, it could be petty. But that's not a reason to do it. That might be the motivation to do it. The legal reason to do it is they think it's prejudicial pretrial publicity. I got to that one. Thank you all. Is it wrong that I want to see the infamous Cartier ring on Ron Richards' finger? Well, if it fits, I don't know. That ring probably wouldn't even fit on one of my fingers. That ring looks small, but that would be highly inappropriate, but it's not wrong that you want to see it because the shade. Question, if Richards provokes Erika and she says something incriminating, can it be used in the lawsuit, or do they see Twitter as something unofficial? I know Richard said Twitter is press. So if they could authenticate the account, possibly, because I've used things said on social media in trials. You have to just authenticate it properly and you have to go about it the right way. Question, if Dad Spears doesn't resign, can the court make an order for him to be removed? Yes, that is the point of that entire motion. They are asking for him to be removed. Yes, the court can do that. Question, why has EJ not been held accountable for not complying with subpoenas and documents? I have not seen that she's not been complying with subpoenas and documents in the bankruptcy, and the other cases were frozen, and those just got permission to continue moving forward. So it will happen. The bankruptcy froze everything. So in the Rui Gomez case, where they were moving along to perfect their liens and to perfect judgments of those liens, that all got frozen. They just got leave to go after that again. And Just Plain Zach and I talk about that on his podcast that I believe comes out on Friday. I'll share it with y'all when it does, which is why you should be following me on social media. Don't forget to go do that at the Emily D. Baker and do the YouTube things, because I will be gone. I will miss 2 Friday Night Lives and a Tuesday stream. So go ahead and make sure you follow me there, because that's where I'm going to be keeping you up to date. I'm going to get to a few more super chats, and then I have got to bounce. I've got to bounce. Ender's Gist said, finally made a live stream. Love your content. Thank you. One of the best legal commentaries I've ever seen on YouTube. Thank you. It's why I'm everyone's favorite legal commentator, because we're the most fun. Others are very smart. There are very smart legal commentators on the YouTubes. I think all of us have different experience that brings different perspective. I just bring more coursey words and shade, I think. I don't think anybody else courses as much as I do. Jay Frentes says, Britney did almost triple the amount of shows for POM and made the same amount for Femme Fatale. Clearly her dad has no business with her money, right? Part of his duty is to negotiate good terms. Where did the money go and who did it go to, and how much was going to her business manager, Lou Taylor? That will be looked into for sure. Jen B said, what conditions have to happen for Dad Spears to go to jail? Ooh, I would like to see the investigation start before I speculate. But for some of these breaches, if they are criminal, yes, there can be jail time, but there can be civil penalties as well. Going through and outlining those is not, I mean, there's so many. It's like, if this, then that, if this, then that, if this, then that. So it's very hard to answer. But there are, abuse of conservatorship and things like that. There are different types of criminal statutes that can deal with this, particularly if they find money was going different places and depending on what other types of abuse they may find. So that's an investigation that's going to happen. And her attorney's a former prosecutor. They're going to have their eye towards that stuff too, because it's in their mind, not just the civil stuff, but the criminal stuff. Bro says, I should be asleep, 3 a.m. Sydney, Australia, but oofed. I had to listen to Britney and her attorney destroy James's ego and finally call out his shady money scheme. Absolutely. Tia Sabo said, can they freeze dad's accounts so he can't hide his money? There's no cause for that yet. If there was cause for it, a court has the authority to do that, but there's nothing right now that gives the court authority to do that. Kira says, please shout out the fans and Jake Yonsei and the Free Britney movement. I sincerely believe that this group was an integral part of her freedom. I think that the Free Britney movement, Jake Yonsei and others have absolutely helped Britney find her voice, knowing that she will be believed. For sure. Tia Sabo said, please tell us that dad will have to pay his daughter back. That was heavily alluded to in this, that they will go after that. This is so wrong to do this to his own daughter. This BS makes me so fucking mad. Same. Lewis Cox said, whoa, this is a big win. 10,000% for Britney, Free Britney. Yes, it is a big win. Amy Z says, it's sickening how everyone, including her lawyer Ingham, financially benefited from this conservatorship. Thanks, Emily, for your detailed coverage. You're welcome. Matt Arnold said, sadly, when you're disabled in this society, you have to fight for every little thing. Matt Arnold, and that shouldn't be the way. We all do things differently, and that should just be okay. Like, it should be okay for people to be different. Why is that so hard? Like, why is that so hard to allow people to be different? I'm going to try to get through these really quick. I appreciate you guys. Ashley Vincent. Oh, oops. I almost forgot. I promised a double catnip tip for my absence last live. No worries. They are appreciative. Thank you very much. Popcorn Planet said, thank you for this important coverage. Big fan. Would love to have you on my channel. Keep up the good work. You are always welcome to DM me, Popcorn Planet. I am a little booked through the end of August, but we will chat. Where can I get that shirt? Need one ASAP. Ender's Gist. This is from the Law Nerd Shop at lawnerdshop.com. 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 For all your merch needs. There's mugs too. I was drinking out of it earlier. So yes, lawnerdshop.com is absolutely where you can go get that stuff. I don't shout it out nearly enough, and I always forget. And Law Nerd Shop is where all the merch is. There's lots of stuff. And the summer stuff's going away soon. So if you want the summer stuff, go do that now. What do you think will happen September 29th at the hearing? Dad Spears getting fired? I sure hope so. I can't see why he wouldn't be. I think that he will be removed. I will be very surprised. I will be very surprised if on September 29th, they don't fire Dad Spears. Todd said, should Gavin Newsom resign for presiding over the enslavement of Britney Spears? Isn't Gavin Newsom being recalled for other stuff? I don't think the governor's directly responsible. I think there are other things the governor of California is probably responsible for, but I don't think he's directly responsible for this or even knew a lot of what was going on. What he knew about the Girardi case, I'm interested in, because he had quite a lot of donations from Tom Girardi. Nicole said, Control plus F plus delete equals James Spears. Control F delete is a whole different situation, but yes. Actually, I'll just leave that up so it's easy to find. Marilyn said, this is flagrant robbery. Now it is publicly known with these court papers. Could it be considered fraud? If there is fraud here, I trust her new attorney and the forensic accountant will find it, and that will absolutely get brought to light. Victoria Quaylis said, if and when Dad Spears gets yeeted off this case, can we have a YouTube live party? Yes. Yes, we can. Oh, but if it's September 29th, I'll be in LA for Vid Summit. So yes, it just might not be contemporaneous. Lynne said, listening in the car well after this super chat. We'll have to listen at the beginning at home. Have a great vacation. Thank you. Sarah H said, can we discuss IG? Britney is not in control of it. CrowdStrike is. There has not been a motion to get it back. Questionable content is getting posted. I don't know enough about what's going on with her IG. Some of the stuff seems like her. Some of it doesn't. It's a lot. Dusty Dew said, do you think he has alienated her siblings, James Spears, throughout this? And if so, is there anything legally she can do about that? Not about alienating her siblings, because it wouldn't be illegal to alter people's relationships in that way. But if there's other conservatorship abuse, it will come to light. Nicole Quaylen, thank you. Sir says, love from the North Pole. Hi, Scandinavia. Or no, it says something. It says, yeah, hi, Scandinavia. Hillary says, a hug from Brazil. Thank you. Monty says, love from Casa Grande, Arizona. My little boy Slade's 11-year-old birthday. Will you give him a big shout out? Slade, happy birthday, buddy. Big shout out. I hope you enjoy it doing the things that you enjoy, which if you're anything like my kids is probably playing Minecraft mods. This is his first time having a school birthday and he was so upset. Fair enough. School goes back really early in Arizona. Ooh, I gotta get bumping. Marilyn said, having a professional fiduciary on board, would it be possible to get back money Britney was supposed to get? Maybe. It depends on the investigation. Snorakin said, hi from Sweden. Happy to join live from the beginning for once. Yay. Adopting a ginger kitten on Sunday. Yay for Ponards. If you share photos on social, please tag me so I see them. KDS Worker says, is strategic plan to eliminate Jamie, keep C-Ship with highly professional fiduciary to do a forensic accounting and financial crimes before dissolving? I think so. I think there is a lot of strategy to this. And I think what you don't want in this conservatorship is to dissolve it. You still right now want the court to have authority over what's going to happen next. If that includes trying to claw back money that shouldn't have been spent, the court needs to still have authority over it. And if the court still has authority over it, it means the conservatorship still exists. So there might be, hello, Savvy, just at the end, there might be a lot of strategic reason to not make a motion to end the conservatorship right now, to allow the court to still have jurisdiction over what has happened in this conservatorship. And that would absolutely be something that would be considered. I've always said, first step is to get rid of Dad Spears. This is my perspective. First steps to get rid of Dad Spears. Second step is to reduce the restrictiveness over her person. Third step is to figure out what the fuck has been happening for the last 13 years. And I think that that's what's going to happen here. That's the way I would attack it. Literally, that's the way I would attack it. Renee B said, if the court had the power to immediately put Britney under a conservatorship without an evaluation, can't they, with all the abuse evidence, can't they immediately rule to end it? The court, I would have to look. With everybody in place, I don't think the court can just rule to end the conservatorship without a motion, because Britney has not asked to end it at this point. They're asking the court to do other things, and the court needs to have jurisdiction to get those things done. If the court ended the conservatorship, the court loses jurisdiction and those things will not get done, and you have to start all over. Starting all over at this point, if you want to investigate Dad Spears and the financial stuff, is a very bad plan. Starting over would be bad. Once Jamie's removed, when do you think they will move to end the conservatorship altogether? Are we talking weeks, months, years? I think months at a minimum, because they're going to want to do a forensic accounting over 13 years. I'm not sure how long that would take. So they're going to want the forensic accounting to be done before they remove it. But that doesn't mean that they can't remove the conservatorship of her person and leave the conservatorship of the estate. There are two. So I think the conservatorship of the person will be restricted and moved first, and then the financial stuff will not be removed until they're done with forensic accountings and investigations and stuff. They want the court to have authority over it. Thank you from Berlin, Germany. So glad to see you thriving. Have you done a PO box run yet? Curious if you've gotten the mini. I am going to the PO box today. I will share whatever I get on Instagram. So thank you, Joy. I will be doing that today. It's been a while. Ender's Gifts just ordered my shirt and mug. Nice website. They really easy to navigate and pay. Thanks. Well, thank you. Thank you for the feedback. I try to make it easy and clean. I built it myself. When I say sometimes we do the things ourselves, we do. Oh, I gotta get scooting. I know that there were a few super chats early on that I might have missed, from Marilyn Snorkin, KTS Worker, J. Mickey D. Can the doctor who diagnosed Britney with dementia be investigated? Question. We don't know if she was ever diagnosed with dementia. That's been reported. I've not seen it in court records. Her initial doctor has passed. So that doctor is dead. And so no, not much you can do. Tori L said, currently 10 days postpartum, had a very difficult labor, delivery, and recovery. I'm sorry. So glad to catch alive and have a bit of normalcy in these long days. Yes, I feel you. I have been there. Give yourself lots of space and realize that you are not really recovered from a postpartum experience with a difficult delivery for months and months and months. Give yourself lots of space. Ask for lots of help. Ask for all of the help you can, and then more help. It is very hard. And then when you feel like crying, just let yourself cry. That's what I found very helpful for me when I was postpartum. It's like, I want to cry. I shouldn't cry. I'm like, fuck it. We're crying all the time. CM Nelson said, would it be cruel and unusual punishment to have Daddy Spears live even a short period of time as he's made Britney to live? Generally, eye for an eye type things do not flow with the U.S. Constitution, though I like where your head's at, and I understand the inclination. Blonderella said, best channel on YouTube. Thank you. Kate D said, oh my God, my first live. Hi from Sweden. Love your videos. Thank you. And that is, we caught up. Y'all, it's time for me to get going. I will be on social. Thank you. Found you 2 weeks ago and love your show. Thank you, Sarissa. I appreciate it. As I said, I will be posting on social. I will be keeping in touch with the text crew for sure about what we're doing and what we're up to while we are on, I meant to put up the text crew stuff, while we are on vacation, but I will be missing the next 2 Friday Night Lives and next week's Tuesday. There will be new podcasts, an episode of The Emily Show. If you're subscribed on your favorite podcast player, it'll just be delivered to you. And then the videos, make sure you have the bell on when those go up live. So I will have some content for you while I'm gone, just not the live streams because it is family time. And I've promised my kids we are just going to do family time. I've also loaded up almost the entire Johnny Depp Amber Heard case out of Virginia on my iPad Pro. I've got lots of cases to get to. There might be some Ace Family stuff on here too, getting ready for when I get back. I've got stuff planned. So while I'm gone, I am going to be reading so that there is new content and new cases when we get back. I appreciate all of you. Thank you for being here. Thank you for being a Leonard. You guys are the best. And I will see you soon. It's time to go. It's time to go. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.